Welcome, friends, family, patriots, believers, conservatives alike. Welcome to The Grid, your intersection of faith, politics, and commerce. I'm really excited about our topics today. Shaun, what are we talking about?
Well, we've got like four topics coming down from the Supreme Court.
The
They've
Supreme
been
Court.
quite chatty and deliverable recently.
It has been, and it's pretty interesting as we read some of these cases. What all you hear in the media is that this is a right-wing court. It's all, everything is dominated by the conservatives. But some of the rulings don't really lend us to believe that. In fact, I have heard that the Supreme Court often votes, I would say 8-1, 9-0, unanimous on most of the cases, these highly charged cases where you start seeing ideological lines being drawn. But there's some cases here that we're going to discuss today that were a little bit surprising. So given the fact that January 6th was the topic of the debate and Jake Tapper was going after Trump on his involvement with January 6th, I thought, since the Supreme Court just ruled on this, thought it might be an interesting conversation to hear what they ruled on and what it means.
Indeed. And I do like that Trump was actually able to seize upon January 6th and flip it by talking about what the state of the country was in that, rather than getting pinned down to a topic he didn't have time to address.
Yeah, it really is, because there's so many nuances to January the 6th. And audience, as you probably know, that's one of the many trumped up charges against him is inciting insurrection on January the 6th. So as we discuss the January 6th ruling, you really need to understand what the charges were. So we have an individual who went into the Capitol and was charged with obstruction of an official government proceeding, which results, it's amazing in our country how you can commit murder in New York and you can walk scot-free. But my goodness, you walk into the Capitol at the end of an election and your entire life can be ruined. I think we've really got that upside down. We're not here to talk about that, but I'm just saying, it really, really bothers me. So this particular individual sued because he said that's not obstruction. Well, you actually have to go back many years. If some of you remember the Enron meltdown, that was all about fraud and abuse and reporting your financial statements and shell corporations and all of this, that eventually led to Sarbanes-Oxley, which is really a financial reporting requirements by the federal government. Well, this whole idea of obstructing an official proceeding actually was born out of that, and it was specifically related to the hiding or destruction of documents. So it was like, to use in that particular case, is the government is issuing subpoenas for information because they want to know how in the world a multi-billion-dollar company has a complete meltdown and that their financials are all fraud. So the government is issuing subpoenas for information, and people are burning them, hiding them, getting rid of them, throwing away, shredding them. And that was what this law was about, is like how to stop that. We're actually gonna create specific charges related to the obstruction of an investigation. So, and we're gonna talk about this later. I think it really dovetails when we talk about the Chevron Doctrine a little bit later, but it dovetails, Shaun, on how the government takes something that's like this and very narrow and expands it to use it for something way beyond that. Do you see that in this case?
I do. I've seen, or I should say, we've seen the Democrat cartel go through and get very creative about existing laws. And let's see if we can stretch this, which is intended to cover zits and pimples, and let's see if we can get it to cover Mount Fuji.
That's exactly right. And so, I mean, you can make an argument about January 6th. You can make an argument that somebody who stormed the Capitol and the doors are locked, that's trespassing. Okay, I get that. If somebody is violent and attacks someone, then you can argue about assault. But you cannot argue that somebody going on the grounds or stepping inside should be charged for obstructing official proceedings under that particular statute when it was really meant for fraud, or not fraud, but the destruction of documents, hiding of documents, and so forth. In fact, I find it interesting. Jamal Bowman, who just lost his primary, by the way, the Democratic primary, was well known for, I don't remember what the vote was, but he was so frustrated because he wasn't getting his way that he pulled the fire alarm. He wasn't in charge. I mean, can you get more in obstructing an official proceeding than pulling a fire alarm that requires everybody to evacuate? He wasn't in charge. So interesting. The Supreme Court said, no, you cannot take this statute and apply it to this situation. This is about the destruction of documents. It's about the hiding of a document. This has nothing to do with this. And this is my view. I didn't actually read the opinion of the court, although sometimes I do because I'm kind of nerdy that way. I think this really has this intersection and this what I would call this healthy tension between the law, but also freedom of speech. And the vast majority of people on January 6th were expressing their free speech rights. The moment you say that you expressing your free speech rights is now obstructing official proceedings and is a crime that results in fines and jail time, that's a problem. That is a problem in our country.
Oh, it's a big problem. It is. And there's something else I'd like to point out at the same time. Ooh, warning, monkey wrench. It's very interesting that simultaneously on January 6th, we have police officers moving fencing. Okay, opening fencing so people can come in and opening doors to let people in, while at the same time, I think I've already said simultaneously, we've got other people standing at doors that are locked and at windows that are closed and trying to beat their way in. So it's like we've got gates and doors opening, and then we have beat these in. Now, I guarantee you, because any smart person, any thinking person could figure this out for themselves, that the folks that were trying to bash things in were instigated by people who were planted at the event. And you know what party they come from?
The cartel.
The cartel.
Sounds eerily like entrapment.
Mm-hmm.
Anyway, I think the what we want to settle on, this is a good ruling. It likely is going to impact Trump because he's charged with obstructing official proceedings as well. And the Supreme Court says, yeah, this just doesn't fly. So I'm happy for other protesters who've been prosecuted under this particular rule, this particular law, because it's going to benefit them as well. It's going to benefit Trump. And I think the Supreme Court found the right balance, found the right spot for freedom of speech. You want to trespass where doors are locked? Okay, charge with trespassing. If you want to destroy property, you can charge with that too. Which, by the way, that really didn't happen. It happened very little in this case. But taking it this far is punitive, and it's wrong. And the Supreme Court found it that way. So pretty excited. I think they landed in the right spot. Up next, we're going to talk about how abortion has reached the land of the potato. All right, Shaun. The Supreme Court ruled regarding abortion in Idaho. Are you familiar with the details of this particular case?
Spotty at best.
Well, I'll be glad to jump in here. At first, I will tell you my thoughts on this case have wavered from where I originally landed because I was hot to trot about this. Because the Supreme Court has said that abortion, the decision on abortion, is remanded to the states because it's not expressly talked about in the Constitution. Again, that was ultimately what ended Roe v. Wade. Did not end abortion, it ended Roe v. Wade. And so when I found about this abortion case in Idaho, so the backdrop of this, Shaun, is that Idaho passed probably one of the more strictest abortion or group of abortion laws in the country. Or I would like to say, not their strictest restrictions on abortion, but probably the most staunch pro-life positions. But what happened is there was this tension between whether a hospital could perform an abortion in an emergency room setting. And the Supreme Court stepped in and said, yes, they can. And there was a little bit of controversy around this case because the official opinion is not out yet, and it got leaked, and they're still kind of working through that. However, as I dove into the details a little bit more of the Shaun, here's what I came to the conclusion. Their issue really is EMTALA. Now, I'm familiar with EMTALA because I come from the healthcare field. It stands for the Emergency Medical Treatment Active Labor Act. It's basically the law that says that when a patient comes to a hospital, you have to treat them and perform a qualified medical exam. You have to stabilize them before you send them somewhere else. It was really, in many ways, called the anti-dumping law. It also requires that you cannot ask a patient about their financial ability to pay, whether they have insurance or not. You can't do any of that before you've actually assessed them, stabilized them if it's possible, and treat them or transfer them to a facility that can handle higher acuity of patients. So as I started reading into this, what really the ruling is saying is that a hospital can be required by the federal government to perform an abortion underneath EMTALA. Well, again, if you understand the EMTALA law, Shaun, I don't even consider this an abortion. The only reason this would be performed under the EMTALA law is somebody truly is in your ER and the life of the mother is at risk. I don't know how you feel about this, Shaun. I just don't consider that abortion, not in the traditional sense as a pro-lifer. How do you feel about that?
Well, for me, I would need to know a little bit more about what the circumstances are. When it comes, I do know that there are circumstances where there has been a tragic, car wreck or something like that, and it's like we can save the mom, but it doesn't look like we're going to be able to save the baby. Okay, in that situation, I wouldn't consider that abortion either, because you can't save them both. The doctor must always be for saving them. But if you can only save the mother, if in an attempt to save the mother, you cannot save the child, then that's not an abortion issue.
And I think that's, Shaun, why after I read this, I became less concerned about this being actually a ruling by the Supreme Court that seemed inconsistent with how they remanded or eliminated Roe v. Wade and remanded abortion decisions to the state. It's because this EMTALA law is a federal law. I mean, it's required by Medicare and, or I should say regulation. And it makes a lot of sense to me that the government was saying, oh, well, we can see how this tension would exist. I can tell you from what I know in healthcare, this situation will rarely occur. So this is not a win. This is not a win for the abortionists. This doesn't all of a sudden open the floodgates for elective abortions in the state of Idaho and rubber stamped by the Supreme Court of the United States. It's not the case at all. So once I read it,
Well,
I was like, okay, I get where they came from.
yeah, even now, it's total balderdash for the excuse of, well, we're going to do this for the sake of the life of the mother. That percentage is so minuscule that it is ridiculous to even try to hide behind that as an excuse.
From a statistical significance standpoint, it's zero. It's 0% for all intents and purposes.
But they talk about it like it happens every day.
All right. Well, next up, we've got two cases that I'm highly interested in that I think are super important. Not that these first two weren't important, but these other ones, when we start talking about the influence of social media, colluding with the federal government, and when we talk about the power of the regulatory agency, these are big deals. So we'll discuss those shortly. Okay, Shaun, the federal government, in this particular case, the White House, and even more specifically, the Biden administration, was sued by multiple attorney generals, mostly in red states, makes sense, for colluding and putting pressure on social media companies to filter, erase, delete, remove content that was not to the federal government's liking. So I think we can all point to COVID. There was a lot of, I'm going to say anti-vaxxers. You know, my family is not really pro-vaccine for the most part. I would say that varies depending on which member of our family you talk about. But there's a whole nother level of being anti-vax that I guess that is on the spectrum, and then you have the pro-vaccine that if that's on the other end of the spectrum, that if you don't vaccinate, then you're a murderer. So you got these extremes and all this in between, right? Well, it turns out that a lot of the people who were opposed to the vaccines were saying this is not a vaccine. The mRNA is really therapy, it's gene therapy. There's side effects. There's all this things that they put on Facebook that the White House was actively meeting with Mark Zuckerberg, with Facebook. There was emails. There's all kinds of things going back and forth showing how they were colluding with them and X, saying you need to take this content down. And it turns out a lot of that information actually ended up being true. It was labeled as misinformation at the time. Another example would be the Hunter Biden laptop. I mean, that one was also, that's completely Russian disinformation, misinformation. It's wrong. Don't share it. Now, quite frankly, I don't really care about the laptop itself. I don't think it would have changed the election in 2020, but it was showed, it was case in point, front and center of collusion of this cartel that we've talked about between social media and the federal government. So the reason I bring this up is the Supreme Court ruled, it's not that they ruled that it was okay for the federal government to do this. What they ruled was the states lacked standing to bring a suit. And that's important, because what the government says is basically, if you weren't harmed, then you don't have the right to bring the suit itself. When I read this, for the liberals saying this is nothing but a conservative court, Shaun, this certainly was a liberal decision. And it was, I believe it was a 6-3 decision, wasn't it? If I remember correctly. And I believe the dissenters were Thomas, Alito, and Gorsuch, if I remember correctly. Thomas is always a dissenter on anything that remotely smells against the Constitution. My favorite justice by far. So anyway, as I read this case, Shaun, principally speaking, I was appalled, and I'd love to get your reaction.
I was ticked. I was smoking hot, and I don't mean good looking. Okay. I was smoking hot. The smoke detectors have been undone from my house. Okay. So this is utter balderdash. We need to have a massive class action lawsuit filed against the mainstream media and name all of their alphabet, give them all their names, and the CDC and the FDA and everybody who participated in saying that ivermectin and hydroxychloroquine were bad for you, that they were horse medications, because there are thousands of people who were not able to get prescriptions for that because of that nonsense, and they're dead. If you have a loved one that died and was not able to get that prescription because they were denied, even some of the pharmaceutical companies, or not the pharmaceutical companies, some of the big pharmacies were saying, no, we're not going to fill this prescription. You're not the doctor. You are not the doctor. You're in business to fill a prescription, period. And they all need to be sued to bankruptcy, as far as I'm concerned. There are thousands of people who are dead because of that nonsense.
Well,
I think what you were expecting for a response?
I think our audience is going to leave this podcast, Shaun, and probably feel a little bit unclear where you stand on this particular issue. I don't know if that was strong enough. And you're really talking about the pressure from a regulatory standpoint. I'm concerned about the free speech component to this. I don't remember what the statistic was, but I remember months ago, something like 60 or 70 or 80% of people, in particular women, get their news from Facebook or social media. And number one, that's appalling in and of itself. I know that when I read a story, I go to multiple. I typically actually will read CNN, Fox News, Newsmax. I go to multiple outlets to try to see, do I see the same story? Because there is so much misinformation out there, unfortunately, and there's misinformation on both sides. My concern is the federal government saying we are the arbiter of what is right and wrong, when the government is inherently biased with their own agenda. they are not lovers of the truth and seekers of the truth. And that was clear in this particular case. I mean, we could point to Anthony Fauci and what he did about trying to curtail the theory that this was a Wuhan lab leak for COVID. And he was like, no, it's not. When there was all these back emails and correspondence going on that showed, in fact, that he had plenty of insight that that's exactly what had happened. And anybody that was posting that stuff was getting their Facebook removed, getting their post tagged and deleted. It's that control. I mean, this is I don't often say that's Nazi-esque, because I think that's a pretty big deal when you start connecting our government's activities with those of Germany back in the 30s and the 40s. But how do you not come to that conclusion when you have
That is what was happening.
Yeah, when you have that
You're
kind
right.
of control and you utilize that control, that is a problem. What's even worse is that I have no clue how our Supreme Court, that is supposed to be an independent branch of government that's supposed to put boundaries on that control on other branches of government, came to this conclusion. So when they say that there wasn't standing, what I don't know if that means if somebody who, like you said, Shaun, was harmed because they made a decision based on information that was wrong, would they have standing? I think the problem is that makes the burden really high to correct this. And so not only is it a problem with what happened, I think it now absolutely opens the floodgates. Here we are about to be in July. It opens the floodgates over the next several months for the election for the government to exercise that same level of control around the election itself. That's where my concern is, Shaun.
Yeah. Well, I mean, the standing issue just is completely, but it's just balderdash, because there are times when you've got a bunch of plaintiffs, they don't have the money to hire the lawyers to get proper justice, but the state's attorney general realizes that injustice has gone on, and the state's attorney general can step in because their budget allows them to cover things like that, and they go to battle for us.
That's right. So just totally disagree with this. It gives the government way too much power. And speaking of the government having way too much power, that's what we're going to talk next about, the Chevron Doctrine. And no, we're not talking about an oil rig in the middle of the Gulf of Mexico. Okay, Shaun, so we're discussing 4 Supreme Court cases today. Did I hold up 5? 4 Supreme Court cases today. This by far is the one that got me the most excited. And I was a little bit nerdy about, I think, as you and I discussed on the pre-show. Really did this is the one Supreme Court got right, and I can't believe that they got the social media one so wrong, and then they got this one so right.
It's like baseball, it's like we've got what was his name? Played for Boston way back in the day before either one of us was born. Babe Ruth. Yeah. I mean, swinging for the fences.
You just offended a lot of people. No, he wasn't Boston.
It wasn't Boston?
Well, he left Boston, the curse of the Bambino. No, he was a Yankee.
He was a Yankee.
Yankee or Dodger, Yankee.
You would think I'd know that growing up in New England, but so anyway, my point is Babe Ruth was always swinging for the fences. And so he had the most home runs, but I think he also had the most strikeouts. So I know, that's why it's not good for me to use sports analogies.
It is true. But it is, I do like it. They got a strikeout on the social media, got a home run on this one. So Shaun, what is the Chevron doctrine? Can I dive into that a little bit?
Well, I didn't know that it was actually named after the Chevron case. And in that case, it was a gas producer.
Yeah, so it it's fascinating to me, and it's going to be hard not to go down all the rabbit trails. But in essence, what the Chevron Doctrine said was the court, I want to say it was 40 or 50 years ago, it was quite some time ago,
40. Mhm.
was a 40. The Supreme Court took the approach that if a federal agency implement a regulation that wasn't specifically stated in the law, so maybe that agency took a little bit of maybe a liberal interpretation of what Congress meant, as long as it was reasonable and made sense, in essence, the courts had no jurisdiction to challenge that. It completely deferred the independent decision making back to the federal agency, which has already been a problem. Sean, actually, I am going to digress a little bit because we've talked about this on the show before about how laws are written so broadly in our country, but it's the regulations that really are the meat. They're the what really you have to live and die by. The law is nothing more than really principle based, and then the regulatory agencies take that law and they say, okay, what are the regulations that we pass in order to make sure that law is implemented as intended? The problem is those regulatory agencies are biased. They're part of the deep state. And I can tell you, the ones that really come to mind are the IRS, but probably most notably the EPA. The EPA is a huge one. And what the EPA has done is Congress will say, we want to, the EPA has the right to regulate pollutants. This is a perfect example. And so that makes sense. The EPA is going to make sure that nuclear power plants are not dumping waste into the water, right? So clean water, clean air, and regulate pollutants. Well, then the EPA writes a regulation that carbon dioxide is a pollutant, even though it's naturally occurring. And then the EPA jumps in and says, we have the right to regulate anything that produces carbon dioxide. So that's cars, that's trees. The EPA has the right to regulate wetlands. So that's the Congress says, well, wetlands or something maybe comes under the EPA's jurisdiction. Well, the EPA then writes a regulation that says a wetland is any place that holds a body of water for more than 12 hours or something like that. Literally a puddle in your backyard could be classified as a wetland by the EPA if they determined they wanted to make an example out of you. So it's really the regulatory agencies have so much power and authority that really has gone unchallenged for the better part of 40 years. It's just, and honestly, when this first came about, it was actually conservatives thought that was a good thing because, and I can't remember the reason why, but in that particular Chevron case, it actually favored a more conservative point of view. But it's been used now to allow the government to just have massive bloat and pretty much rewrite anything it wants that Congress produces. But more importantly, the court basically said, we don't even have, ourselves don't even have the right to review this because that's the agency's job. Well, why does that all that matter? Because in the Chevron case, the Supreme Court just changed that. The Chevron doctrine is as dead as Roe v. Wade now. It's gone. Actually, it's more dead because it hasn't been remanded to the states. It's done. The Supreme Court basically took the approach that not only is that incorrect, we actually have a duty as an independent branch of government that if we think a regulatory agency, even if it looks like they've reasonably done what they did, it doesn't matter if it's reasonable if we don't think that was Congress's intent, and therefore the regulatory agency has stepped out of bounds or done something that appears to be unconstitutional. We have the right and the duty to look at that and review that in court. Absolutely the right decision, Sean. So Sean, I'm sorry, I totally went off and ran with that. I think the Supreme Court got a home run on this one. What say you?
Well, I think that I every part of what you just said nailed it. The thing that gets me is like, and it lines up with that is, look, we can't, when it comes to contracts and things of that nature, you can't put something in the contract that violates the Constitution. You can't put something in any kind of agreement or deal with a company or with a client where anything violates the Constitution. You can't stifle free speech. My rights don't end because I walked into your building.
Yeah, that is so true. And it'll be interesting to see. So of all the cases we've discussed today, the abortion case, I think, in Idaho is not that big a deal because I think the occurrence of that situation is going to be so limited. The January 6th protest case is definitely going to have some impact on those protesters who are currently under prosecution. The social media is going to have a big negative impact, but it already has had a negative impact. So it's not going to be a change from where we are right now. This particular case, the Chevron Doctrine, I think the future of this is significant. And I think it's going to take weeks and months and years for some of the regulatory agencies' power to be unwound. But I think the future looks bright in light of this case and the authority of the regulatory, the fourth branch of government, the regulatory agencies.
Well, I agree with Justice Ketanji Brown that there probably will be a flood of cases because these agencies have ruled the wrong way. You know, what Scripture tells us that when the wicked are in power, it's a mess. The people suffer. Where the righteous are in power, there's peace. And so, yeah, I agree with her. There are going to be a lot of lawsuits because these agencies have tried to pull fast ones, and they are draconian or tyrannical. Like you said, claiming that a mud puddle that shows up only when it rains is a wetland. Come on. They need their butts whipped. And that's see, when Congress abstained from doing their job and they just did general brushstrokes, that would be great if the agencies were run by the righteous. The problem is they're run by ideologists with an agenda, and that agenda is not righteous.
I'll give you another example, Shaun, because you're spot on. Another example where we can see this is the Civil Rights Act that was passed by Congress, where it says that no one can be discriminated on based on race, religion, sex, and so forth. And the federal government is taking the approach that sex means how you identify, pronouns, transgender, LGBTQIA+, the whole gamut. And that's clearly not the case because those conversations weren't even happening when the Civil Rights Act was passed. But the regulatory agencies that implement that have taken that approach. The executive branch has taken that approach, that's exactly what Congress meant when it's not true. And so Congress needs to address that and bring clarity to that. But to me, in light of this case, that's another example of one that the Supreme Court's gonna say, you just don't have the right to do that. You don't have the right to make that assumption. It's not a reasonable assumption.
Right. And the court is being accused of being right-wing and all this. And oh my gosh, they're trying to destroy our democracy. No, what's being destroyed is a wicked agenda that is trying to remake America into something she was never supposed to be. Their idea is freedom. Their definition of freedom is the freedom to sin. The definition of freedom by our forefathers was the freedom to follow our conscience.
You know,
and there's a big difference.
That's probably a whole nother podcast, but you're talking about, in many ways, we have different definitions of the same word. Conservatives and liberals have different definitions of freedom. I listened to a podcast this week that I thought was so interesting that talked about that the liberal pundits who are talking about that Trump is going to destroy democracy, they don't have the same definition of democracy that we do. Number one, we're not a democracy. Sorry to break it to you, audience. We are a republic. We're a representative republic. We elect people to represent us in Congress. A true democracy of 330 million people would be absolute chaos, but I digress. So when I think of freedom and I think of democracy, I think of the ability to freely elect those who would represent us and represent our point of views consistent with the Constitution at the federal level. When the progressive liberal says democracy threatened, they are talking about the very thing we're talking about here is these regulatory agencies losing their power to do their bidding. That's what they call the loss of freedom and the destruction of democracy. And by that definition, I say destroy it all.
Mm-hmm. Yeah, exactly. So when they talk about, Trump is going to destroy, he's going to destroy he and we are going to destroy their agenda. but the country and our constitutional republic will remain.
It'll
And
be
that's the whole
stronger.
point.
Actually, it'll be stronger.
Yeah, because we get rid of all the stuff that is literally causing our country to crumble. All you have to do is look at the cities that are coming apart at the seams, and guess who's in charge of them? Every one of the cities that we've got that are crumbling before our eyes, they're all run by the same cartel.
They are. There's no
But I
doubt. Well,
digress.
Shaun, number one, I hope this was helpful to you, the audience. I get a little bit nerdy about these court cases because I enjoy reading them. I enjoy hearing the thought process, or in many cases, on our liberal justices, the lack of thought processes of how they come to their conclusions. It's fascinating to me, and maybe because the rule of law is important. Our country is founded on laws. It's founded on our Constitution. These things are important. This is why who you elect as president. There may be no other important. There may be no other reason that's more important than the president than the fact that they appoint justices to the Supreme Court. And I think you're seeing that right here. Shaun, any closing thoughts after we discuss these 4 cases today?
Well, as usual with the Supreme Court, we have a mixed bag, but I think overall, we've got a general win, when it comes to these 4 cases, and we've got the biggest one coming up next week, as relates to when this podcast is being recorded. So next week is whether or not the President of the United States, what's that term that they're looking to do, has immunity.
As immunity,
And
executive immunity.
he should, because hear me loud and clear, my Democrat friends and family. If the president doesn't have immunity, then Biden and Clinton and Obama can be investigated down to their friggin' DNA.
Which we don't want that. I don't want presidents and prior presidents being prosecuted.
No, there's stuff I don't agree with them about, but guess what? They have to talk about issues in their entirety. They need to know where the boundaries of the law are so that they can know how far they can go and what they need to avoid. And so sometimes they're going to ask, is this legal? Is there a version of this that is legal? And under the things that are taking place right now, under the kind of investigations that they're doing, they're basically turning those innocent conversations where they're just seeking information and to understand what the boundaries are, they're going to turn those into criminal offenses.
That's right.
And that is ridiculous. I don't agree with Obama about a lot of stuff, but he needs to be protected. And if there's something really big that he did that meets or exceeds Watergate, we have ways to deal with that already.
We do. Shaun, it was great to visit with you today. Like you said, I think the Supreme Court mostly got these cases right, with the exception of the social media case. I think the court's been moving in the right direction. I think the fact that we've got a majority of folks on there that are interpreting it according to the Constitution is a win in of itself. And we can't afford to put someone in the White House that is going to start putting more Sonia Sotomayor's on the court. That would be disastrous.
Exactly. You've been listening to The Grid, the intersection of faith, politics, and commerce. Till next time.
Till next time.